Hello, I'm James Hutchinson, a partner with Beale Company. Thanks to everyone for joining us today. Today I'm going to give you a whistle-stop tour of the General Data Protection Regulation, known as the GDPR. The text of the regulation is about 90 pages long and contains 55,000 words, so I'll focus on some of the key issues which I think are relevant to members of the CIHT. If we have time, I'll answer any questions we receive at the end of the webinar. Otherwise, I'll assume you're happy for your questions to be anonymised and we'll circulate some answers after the webinar. You should be able to ask questions using a box on the side of your screen. If there are any problems, you can post a note. So there are a few things to note about the GDPR. Whatever your views on Brexit, you may have secretly hoped the GDPR will quietly disappear. But the UK will implement the GDPR on the 25th of May 2018, so you've just over 1 month to get ready. The government is also introducing a new data protection bill, which will make some changes to how GDPR is applied in the UK. The main ambition of the European Union is to establish a one-stop shop for data protection, with a consistent set of data protection principles applying across the EU. The GDPR has what's called direct effect, so it will apply to each member of the EU without the need for any local legislation. Though you may find, as we're introducing a new data protection bill in the UK, different countries might have their own slight takes on the GDPR, but it will all be very similar. The regulations significantly increase the potential fines facing companies, with the maximum penalty for breach of the GDPR being 20 million euros, or if higher, 4% of a company's worldwide turnover. This is compared to a maximum penalty of £500,000 under the Data Protection Act. So what you can see is a vast increase in potential fines. The GDPR applies to all areas where companies process personal data. So the original Data Protection Act came into force in 1998 and a lot has changed since then. Back in 98, Scotland had just qualified for the World Cup finals in France. The Spice Girls had a string of number ones. Google was founded. It would be another 9 years before the first iPhone was released. Facebook creator Mark Zuckerberg was only 14 at the time, and Facebook probably hadn't even been thought about. And Netflix had only just started renting DVDs by post. So what you can see is that the world of social media, iPhones, Fitbits, and various apps that we're all used to on a day-to-day basis has drastically changed how we use and share personal data. The Data Protection Act, unfortunately, has been unable to keep up with those changes, and this is one of the main reasons and drivers for the GDPR. The GDPR takes a similar overall approach to the Data Protection Act and sets out a number of key principles for the processing of personal data. Terms like personal data, processing, data controller, and data processor will hopefully all be familiar to you. Most CIHT members will be a data controller, and you must ensure you can meet at least one condition providing the legal basis for processing. At the same time, you must give your clients, your employees, who are the data subjects, information on the purpose of such processing. Data subjects have a number of rights, such as subject access rights, to obtain information on how their data is processed. And whilst this is similar to obligations under the existing Data Protection Act, continued compliance is going to require increased granularity, an increased emphasis on the legal basis for the data processing, even more detailed policies and information, if you can have more detailed than you've already got, and additional rights for data subjects. Non-compliance risks being penalised with even larger fines than you're used to at the moment. And I suspect the Information Commissioner's Office, the ICO, is going to make examples of the first few organisations that make significant breaches of the GDPR. We all think that this will probably be kind of, finance institutions, insurance, and social media businesses like Facebook, Google, etc. However, any business might get caught in that. And the issue of transparency runs like a thread through the GDPR. Previously, data had to be processed fairly and lawfully, but the GDPR adds this concept of transparency. So in the context of your relationships with clients, that means you have to be open and explain what you're doing. Say, for example, if you were to receive a subject access request, so that's a request from an individual asking for copies of their data, whereas before you might have responded to the request and provided the information, you now have to explain how you approach responding to the request, not just provide the data. So there's that subtle change of explaining all your actions. So when you send the information, you should provide a narrative setting out, how you went about it and what your thought processes were. Obtaining consent from an individual is one of the methods by which you can establish a legal basis for processing personal data. And Article 7 sets out stricter and more detailed conditions over when consent can be used. So consent has to be freely given, specific, informed, and unambiguous. And consent is not freely given if there is no genuine free choice. For example, consent is not given by an employee if they just sign up to words in an employment contract. You have to set aside and flag up the GDPR relevant provisions. The onus is now on data controllers to show that an individual has given consent. If consent is given by means of a written declaration, that request must be made in a manner that is clearly distinguishable from other aspects of the document, for example, what I just mentioned about the employee. An individual has the right to withdraw consent at any time and must be told of this right. It must be as simple for them to withdraw consent as it was for them to give it. And where consent is relied on for the processing of any sensitive personal data, so for example, if you're collecting any kind of medical information, consent has to be explicit. So you should really consider other grounds on which you can process and justify your processing. Article 6 sets out that you can process personal data where without consent if it's necessary for a contract with the individual. So for example, to fulfill obligations under an employment contract, compliance with a legal obligation. So if you're required by any UK or EU law to process the data for a particular purpose, what's called vital interests. So you can process personal data if it's necessary to protect someone's life. This could be the life of the data subject or someone else. If you're performing a public task as part of your official functions, which is in the public interest, then you can process, but you also have to have a legal basis for the processing under UK law. And you can also process personal data without consent if you have what's called a genuine and legitimate reason. And that can include a commercial benefit for you. But this has to be weighed up against the potential harm to the individual's rights and interests. These are quite esoteric concepts, but the ICO has published guidance on consent and legitimate interests, and both are available on their website. Data controllers are currently required to provide data subjects with a privacy notice, sometimes known as a fair processing information. This sets out the purposes for which data is processed and further information to ensure processing is fair. Under Article 12 of the GDPR, all information provided must be concise, transparent, easily accessible, and in plain language. You must also provide information on the legal basis for your programming. Data controllers have to explain the sources of any data, unless it comes from the individuals themselves, who's going to receive the personal data, or the categories of recipients, for example, some other parties, if you're sharing that data, the period for which the data will be stored, or if that's not possible, the criteria used to determine the period, the existence of the individual's rights, including to access, rectify, and erase the information, the right to object to processing on grounds related to an individual's particular situation, the right to withdraw consent if the controller is relying on consent, the right to complain to the Information Commissioner, and the legal basis for transfer of any data outside the EU. So this is a significant increase in the amount of information which a controller must provide. It's still not clear how data controllers should balance the level of data required and the obligation to provide information concisely, accessibly, and in plain language. We're trying to do that as much as possible with the drafting we do, but the documents do tend to be quite long. And it's a difficult balancing act to provide all the information, but to make sure it is in plain English. So the GDPR extends individuals' existing data rights. In addition to the subject access right, there is a package of rights that have been summarized as the delete it, freeze it, and correct it rights. We'll look at these in a bit more detail in a minute. The data subject access right in Article 15 of the GDPR is broadly similar to the right under the existing rules. However, data controllers will be required to provide some extra information, including the envisaged period of storage, details of the delete it, freeze it, correct it rights, the safeguards applied on any third country transfer of data. When it comes to a subject access request, controllers currently have to comply within 40 days. This is going to be replaced with an obligation to comply without undue delay and within 1 month, with an extension of up to 2 additional months if necessary, taking into account the complexity of the request. Well, given the complexity of most subject access requests I've ever seen, it seems to me likely that the normal period now for compliance is going to be up to 3 months. The £10 fee under the Data Protection Act is going to be abolished. However, where a request is what's called manifestly unfounded or excessive, the controller may either charge a reasonable fee, taking into account administrative costs, or may refuse to act on the request altogether. So this is a significant change. What is manifestly excessive? Well, I think it will depend on the specific circumstances, but it's likely to discourage onerous subject access requests and will probably be, I think, a useful tool for you to bat them back if necessary. I'm hoping the Information Commissioner will come out with some further guidance on what is manifestly unfounded or excessive, but I haven't seen that yet. As well as changes to subject access requests, individuals have a new package of rights, including the right to rectification, the right to erasure, so that's the right to be forgotten, the right to restriction of processing, the right to object to processing, the right to object to automated individual decision making, including profiling. The circumstances in which these rights can be exercised vary from type to type, but generally they're triggered if there's a breach of the data protection principles. Data portability is a new dilemma for data controllers. The right allows individuals to obtain and reuse their personal data for their own purposes across different services. It allows them to move, copy, or transfer personal data easily from one IT environment to another in a safe and secure way, without hindrance to usability. The aim is to enable consumers to take advantages of applications and services which can use their data to offer them a better deal or to help them understand their spending habits. But data portability only applies to personal data an individual has provided to the controller, where the processing is based on the individual's consent or for the performance of a contract, and where processing is carried out by automated means. I mean, unsure really how this will impact on the kind of data that you're looking at, but you'll need to review what you hold. It's quite likely some of it is held on different systems. For example, imagine your personal data has been collected via a traffic management system. You'll have to work out how practically you can supply this information to an individual and potentially your competitors as well. The EU's Article 29 Working Party has published guidelines and frequently asked questions on data portability for organisations, and that's on the EU website. Solely automated individual decision making, including profiling with legal or similarly significant effects, is going to be restricted under GDPR. Automated decision making is a decision made by automated means without any human involvement. So, for example, might be if you run a recruitment aptitude test for some employees, which uses pre-programmed algorithms and criteria. Automated individual decision making does not have to include profiling, although it often does. And profiling is described in the GDPR as any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a person, in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, locational movements. Locational movements, obviously important to some CIHT members when looking at traffic data. Information is analyzed to classify people into different groups or sectors using algorithms and machine learning. This analysis identifies links between different behaviors and characteristics to create profiles for individuals. Based on the traits of others who appear similar, profiling can be used to find something out about an individual's preferences, predict their behavior, and/or make decisions about them. This can be very useful data for controllers as it can lead to quicker and more consistent decisions. But if used irresponsibly, there are significant risks for individuals. The GDPR provisions are designed to address those risks. Article 22 restricts you from making solely automated decisions, including based on profiling. It says that the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or significantly affects them. The restriction can be lifted in certain circumstances. You can only carry out solely automated decision making if the decision is necessary for entering into or performance of a contract between an organization and the individual, authorized by law, for example, for the purposes of fraud or tax evasion, or based on the individual's explicit consent. So going back to the consent we were talking about before. Because this type of processing is considered to be high risk, the GDPR requires you to carry out what's called a Data Protection Impact Assessment, a DPIA. And that's to show that you've identified and assessed what those risks are and how you're going to identify them. These new restrictions are likely to be significant for anyone conducting the systematic profiling of individuals. Big data projects looking for fraud detection or including targeted marketing are also likely to be affected. Some profiling should remain permissible if it falls within the necessary for the performance of the contract exclusion. However, profiling for marketing purposes will always require explicit consent. Data controllers have a duty to comply with data protection principles, but the GDPR also requires it to be able to demonstrate compliance. In principle, the Information Commissioner may require controllers to implement technical and organizational measures and to show how they comply. It won't be sufficient to say we're not in breach. Compliance must now be demonstrated. Where proportionate, the GDPR requires implementation of data protection principles, which is an organization or technical measure. This is likely to lead to a proliferation of new policies. If challenged, it's better for a controller to be able to say that it has a policy with which it complies. Controllers will be expected to take steps to build data protection into system design. Subject to what is really kind of technically practicable and cost, you will need to build in safeguard to comply with the rules. Measures must be taken to minimize data collected, ensuring it's necessary for the specific purposes for which it was obtained. So when you're contemplating new IT systems, it's advisable to consider and ask some questions about to the extent that data protection can be built in. There's now an enhanced requirement for a written contract to be in place between a data controller and a data processor. The contract is important so that both parties understand the responsibilities and liabilities. The GDPR sets out what needs to be included in the contract. In the future, standard contract clauses may be provided by the European Commission or the ICO and may form part of a certification scheme. That would save you having to put in your own long words and long clauses. However, at the moment, no such standard clauses have been drafted. I don't expect any to be imminent. The controller is liable for their processor's compliance with the GDPR and must only appoint processors, and this might be your subcontractors, for example, or subconsultants, must only appoint processors who can provide sufficient guarantees that the requirements of the GDPR will be met and the rights of data subjects protected. Processors must only act on the controller's documented instructions. They will, however, have some direct responsibilities under the GDPR, which is new, and may be subject to fines or other sanctions if they don't comply. So the same fines that you could potentially be liable for. The contract must set out the subject matter and duration of the processing, the nature and purpose of the processing, the type of personal data and categories of data subject, and the controller's obligations and rights. Contracts must include as a minimum the following terms requiring the processor to only act on the controller's written instructions, ensure that people processing the data are subject to a duty of confidence, that they take appropriate measures to ensure the security of processing, only engage sub-processors, so this is the sub-processor of the processor, with the prior written consent of the controller, which is presumably you, and under a written contract, assist the controller in providing subject access and allowing data subjects to exercise their rights under GDPR, so there's those rights we talked about before about erasure, rectification, etc. Assist the controller in meeting its GDPR obligations in relation to the security of processing, the notification of personal data breaches, which we'll look at in a moment, and data protection impact assessments, delete or return all personal data to the controller as requested at the end of the contract, and submit to audits and inspections. As a data controller, you'll ultimately be responsible for ensuring that personal data is processed in accordance with the GDPR. Unless you can prove that you are not in any way responsible for the event giving rise to damage, you're going to be fully liable for any damage caused by non-compliant processing, regardless of your use of a processor. This ensures that the data subject is properly compensated. However, you might still be able to claim back all or part of the compensation from your processor to the extent that it's liable. A processor can also be held liable to pay compensation for the damage caused by its processing where it's failed to comply with GDPR provisions specifically related to processors, or where it's acted without the lawful instructions of the controller or against those instructions. The role of a data protection officer is to advise the data controller of its legal obligations. It's to monitor compliance with the GDPR and with data policies and related training, and to be a point of contact for the regulator, so the point of contact for the ICO. A data protection officer is independent, with a position in some way analogous to an auditor. Data protection officers may be employees, contractors, or outside consultants. Although some companies will appoint data protection officers voluntarily, there's only a requirement for a controller to have a DPO if its core activities involve systematic monitoring or large-scale processing of sensitive data, for example, health data or criminal records, or if it's a public body. The GDPR places new obligations on companies in relation to data breaches. This is a move towards the US model of notifying breaches to the regulator and those affected. For me, this is one of the biggest changes that is brought about by the GDPR. So what is a personal data breach? Well, Article 33 defines it as a breach of security leading to the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of personal data. For example, sending an email to the wrong person or leaving a laptop in a restaurant are both data breaches. On discovering a personal data breach, the controller must notify the ICO promptly and within 72 hours if feasible. If the notification isn't made within this time, the controller must provide a reasoned justification explaining the delay. However, the notification requirement doesn't apply if the breach is unlikely to result in a risk to data subjects, for example, because all of the data on the laptop was encrypted. You might think something similar as well. If you've sent an email to an individual and it has and it had an encrypted attachment, in that instance, you may well then take the decision that there isn't a risk to data subjects. In notifying a breach, the controller must describe what happened and set out the approximate numbers of individuals affected, the likely consequences, and the measures taken or proposed. If there's a high risk to a data subject, they must be told. Records must be kept of all data breaches and actions taken, including those in relation to which there was no obligation to notify the regulator. Although not all such breaches are serious in their impact or need to be notified, the 3-day time frame means that the controller will need to have clear policies on how you handle a breach, with defined roles fulfilled by individuals who understand what they're doing. So you really just need to have the training in place so that if there is a breach, anyone from the administrative staff all the way through to senior management know what a breach is, how they should report it, and they shouldn't be personally penalized or be worried about reporting that. You need to have a kind of open culture because you have this deadline to report within 72 hours. A question that I'm often asked is, well, are any of these data protection fines insurable? We've got cyber liability insurance. Will it cover us? Well, it's still a bit of a grey area and depends on the particular facts of the claim. My personal view is that in most cases, the fines are unlikely to be insurable. One of the key issues is whether a fine would be considered criminal or quasi-criminal. If it is, then due to public policy, the courts are unlikely to allow a fine to be indemnified by another party, i.e. your insurer. To do so would mean that the fine wouldn't have its intended effect, which is to punish the party in breach of the GDPR and to act as a deterrent to others. Penalties are meant to be punishing. Article 84 of the GDPR requires penalties to be effective, proportionate and dissuasive, and due regard should be given to the intentional or negligent character of the infringement. There might be some circumstances where you could be indemnified for fines arising from an unlawful act of strict liability, although for these sums to be indemnifiable, your actions would need to be almost entirely free of fault. We've seen similar fines levied by the OFT or the FCA not being recoverable under insurance, so I think this gives us a bit of steer about how the courts might act. The wording in most cyber liability policies is along the lines of, we provide cover for fines where insurable. Looking at one policy, it covers data protection fines that the company is legally liable to pay. But the term data protection fines is itself defined as any lawfully insurable fines. In my view, this gives quite a lot of scope to insurers to avoid cover if necessary. So we're just over a month to go. I hope I haven't scared you too much. I expect you're already well into planning your response to the GDPR, but I wanted to highlight some steps that you should be focusing on in this last month. And that's really to identify all existing data systems and the personal data that you're processing, to determine the legal basis for processing the data and identify what will need to change to comply with the revised regime. Ensure you've got the resources to prepare those changes and that you've allocated the task correctly. If you don't have the proper resources, I still think it's there's still sufficient time to remind your boards about the potential fines that you could face. I view compliance for most organizations is a bit of a process. You might not be 100% compliant by the 25th of May, but you should be well on the way, and you should be updating things even after that date as well. Identify who takes overall responsibility, ensure they've got the support to plan for all these reforms. You need to review your contracts of employment, your handbooks, policies, etc. to see whether and how they deal with data protection. You should ensure that you've got data processing agreements in place with your key data processors. Establish a clear policy for handling data breaches. Obtain a full picture of the exposure you have to potential data breaches by ensuring that breaches and loss are reported in a simple way to whoever is responsible. Train staff on data protection responsibilities and how they are affected in their job. And develop and implement a policy of retention and storage of data. So I've put on this slide some useful resources. it might be a typical lawyer's comment, but try and have a look through the text of the GDPR itself. I think it's well worth seeing how it's written, some of the phrases used, how the paragraphs kind of link to each other. Don't spend more than 10 minutes sort of flicking through it, the text itself, but I think it's well worth doing. It's also very, very worthwhile going through the helpful guidance produced by the Information Commissioner's Office. The ICO keeps publishing additional info on its website, lots of guidance notes, steps, plans, checklists, things like that. Keep an eye out for updates. There's a lot of links on there. They should all be on the slides as well. There are a few questions. What I would like to do is take away these questions, because quite a few of them are relatively technical, and I think a fuller answer would be useful. So what I'll do is I'll take away those questions and I'll anonymize them. If anyone doesn't want their question to be circulated at all, please let me know. Just send me an email. If you've got any other questions, feel free to drop me an email. The address on it is on the slide, and I'm going to circulate the slides to everyone that registered today, and you'll also receive a link so you can listen again in case you missed anything, if you really want to listen again. So thank you, everyone. I know it's been relatively short and a sort of a quick plow through those main points of the GDPR. I hope you found it useful, and thanks very much for taking part today.